Good afternoon. Thank you for being here on short notice. We're here on 3 matters. We're here on the estate matter, 223-500-019, in the matter of the estate of Eric Richins. Mr. Tracy, you're here on behalf of the trustee. Is that correct, sir?
On behalf of the personal representative.
My apologies. Thank you. Very good. Do we have anybody else that needs to make an appearance on the estate matter?
I think Mr. Gorange from my office is also on. And Ms. Richards Benson, the personal representative, is on.
Yeah, and Your Honor, Austin Nate on behalf of Corey Richards as well.
Very good. Welcome to both of you. Thank you. All right. We're also here on I'll refer to it as the civil matter. That is 220-500-076. Mr. Nate, are you making your appearance on behalf of Ms. Richins in that matter?
Yes, Your Honor. That's
Thank you. And then Mr. Tracy, same for Katie Richins Benson?
Yes, as trustee of the trust, yes.
Okay, thank you, sir. And then Ms. Chandler, the private guardian ad litem?
Yes, Your Honor.
All right, very good. Mr. Sins, do me a favor. If you're not speaking today, turn your video off for me. Thank you, sir. And then we're here on the criminal matter. 231-500-139. Ms. Cassell, Mr. Bloodworth, Ms. Olson, all on behalf of the state. And then Ms. Lazaro. Anybody else that needs to make an appearance?
Yes.
Aaron Hinn, Your Honor, on behalf of Ms. Richins.
Got it. Thank you, Mr. Hinn.
Joseph Hill on behalf of the state.
My apologies. Thank you. Do you want to be officially attached, Mr. Hill?
Yes.
Okay.
Austin Nate as well, if you're on.
Yes, Your Honor. I'm also in the criminal.
I've got you there. Thank you.
Thank you. Appreciate it.
We can do a notice. We could do a
Notice of appearance.
notice of appearance.
Very good, if you wouldn't mind. All right. The state filed a motion for gag order in the criminal case. The breadth of their request is quite broad and implicates lawyers, parties, potential witnesses that also exist in the estate case and the civil case. So it makes sense to handle this all together and once, at least under the current set of circumstances. I've looked at the motion. I've done some research. I have many questions. Who's handling this for the state?
I am, Your Honor.
Ms. Cassell.
Yes.
We have a First Amendment problem here. If we can break the categories of people potentially restrained down a little bit. So we have counsel of record in the 3 matters, and that implicates Rule of Professional Conduct 3.6, which is not an absolute bar. It has lots of twists and turns. Then we have parties, named parties in the 3 matters. And then we have everybody else, who potential witnesses, people about town and county. How do you see this breaking down?
Well, I see it breaking down people who actually have, knowledge of the case, law enforcement, court personnel, anyone associated with those offices. For instance, our office, not just the attorneys of record, but the attorneys, but the folks within the office that are working on the case or even not working on the case, that have access to the case. Those court personnel who may have access to the case, law enforcement officers and those that work within that office.
Do we have a genuine concern, though, that court personnel or law enforcement are going to speak inappropriately about this?
I think the concern more is that there's potential to be approached by outside, by the press, by those, and I think that the pressure put on them. I think that is more of the concern. I think am I concerned about court personnel or law enforcement? No, I don't have any reason to be, but I think there is that risk of somebody approaching, say, somebody who works, and again, this is all hypothetical, and I have no reason to believe that this has happened, but hypothetically, someone could approach, say, a secretary in the sheriff's office who has access to all of this information and offer a financial incentive to speak to them. I think that having this extra level of protection, that is actually a violation of court order, that somebody could be brought before the court for for contempt, I think is the reason, part of the reason why we're doing this. We absolutely understand there is a need for reporting on this. We're not trying to somehow keep the press from reporting, but we are trying to keep it, limited to what's in the public record, or what happens in court, what happens, what's been filed with the court, but not to try to dig in to something that isn't in the public record or that they're not entitled to. And I think that's the concern here. And I think that having that extra protection of a court order prohibiting those associated with the case from talking to the press would protect. I mean, this is a protection for not only our witnesses and the integrity of the case, but to the defendant herself. I mean, this is a way to ensure that the jury pool isn't tainted, that the case itself isn't tainted, and that to protect her right to a fair trial.
I need to ask you some questions, just to understand the bounds of the argument here. First, I'm not sure I have the authority to enforce an order against people that are not counsel of record or parties in the cases. I can't hold another citizen in the county in contempt. Can I?
I think that would be difficult, this is a random citizen in the county. But I think that's why I think we're limiting it to law enforcement, to those who are, I mean,
I don't think I have, I mean, that's a reasonable argument, but do I really have authority over every law enforcement officer in the Summit County Sheriff's Office?
I think as an extension of our office, yes, because they are the investigating entity, I think you do. I think you can order that any, they are prohibited from discussing the case.
Okay. Again, just to understand the balance of the state's argument, a series of hypotheticals. If Corey Richens wants to do a podcast episode from jail, why shouldn't she be allowed to do it?
But she's a party to the
Right.
to the event, to this. I think if you're ordering the parties not to, I think you have jurisdiction over the parties.
But why should I? Why shouldn't she have that right to speak and say what, I mean, notwithstanding that her counsel would have some strong opinions about whether she should say anything, but doesn't she have that right?
Well, if that is going to hurt the integrity of the case, I think it's her protecting her, but it's also protecting the integrity of the case. I think the state also has a right to have the case proceed without, I guess with integrity would be the way I would put it. And I think that if that inhibits that proceeding, then I think you could order her not to speak.
What if one of Eric Richens' family members wants to do a podcast episode about what he or she observed of Eric and Corey's relationship while he was alive? Do I have any basis to restrain them from doing so?
Well, I would just make the same argument that if that is somehow, I think if that somehow, I think we would suggest to them not to do that.
Right.
And I think that if you're going to limit witnesses from making from making statements, I think that would apply to them because they are potential witnesses.
All right. Let me just go around the table here and see if anybody else disagrees with you. I'm not even clear if anybody disagrees with the state at all on this. But
Okay.
Let me
Do you want me
see.
to sit down?
Yeah, if you don't mind, just for a moment. Ms. Lazaro.
Thank you, Your Honor. I guess, first and foremost, I'd ask the court to reserve any temporary ruling unless for further briefing on this.
Okay.
It wasn't filed as, an emergency ex parte. I appreciate you wanting to address that early on, but I do think it's something that we would probably want to look at a little bit more in depth for a lot of the same questions that you raised with the state just now. First and foremost, there's really no exigency at this point to do it. The press that's out there happened almost instantaneous. It was in response to the information that was filed by the state. We can't undo what's already out there. So from that standpoint, they can, all they're going to do if a gag order is in place is continue to reprint the same press without ever giving Ms. Richens, a fair opportunity to rebut that, which I believe under the First Amendment she has. So, I think in essence, the filing of the motion of the gag order really does nothing but prohibits Corey from, or anyone on her behalf, ever putting out anything that disputes what the state has already said. So from that standpoint, I think there's a disparity in how it actually does taint the jury pool, because then the only narrative out there is what's been filed in the information and nothing else. And no one is allowed to ever present anything different. To your point, would I support my client making a podcast? Absolutely not.
Right.
But in the essence of fairness, I don't think, given what's already out there, that one, there's any exigency because we're not going to undo it, and two, gagging anyone now is just going to create a disparity in fairness as to what is actually reported in this case. As you brought up, there's already rules in place that govern lawyers. I get that 3.6 isn't an absolute bar, but we are bound by the rules of professional conduct and what we can say and do.
May I ask you about that?
Yeah.
So the enforcement mechanism of 3.6, absent a court order, is pretty loose.
Right.
Requires this lengthy process through the Office of Professional Conduct. Other district courts in the state of Utah have made the provisions of 3.6 a court order so that there is an instantaneous enforcement mechanism. Do you think there's any value in that?
I don't necessarily have any objection to that, only because I don't ever want to be on the other side of a bar complaint with the Office of Professional Conduct, so I intend to follow that. I don't, from that standpoint, making a court order that we comply with the rules I would take no issue with. If
All right.
the court felt like that were necessary. To date, my only comment has been no comment, so, nothing's been put out there anyway. I likely, or also share your view on jurisdiction. I don't necessarily believe the court has jurisdiction over anyone except for attorneys and Corey, essentially.
Well, I certainly have jurisdiction over Katie.
Correct, in the other case.
Yeah.
But aside from that.
And maybe, the juvenile court has jurisdiction over the kids.
Correct. But they're young. I don't necessarily expect the kids to be out there saying anything. So, I think to the extent what the state's seeking to essentially protect people from harassment, which I actually appreciate. I don't think your court staff should be followed around or hounded by press or any of those things. And so from that standpoint, I get it. I just don't think that the court necessarily has jurisdiction over people who want to say things that they want to say. I think that's, outside of us. So I think from that standpoint, I don't think it serves to actually do what the state is arguing that they're concerned about. Additionally, and I gotta be honest, we've dealt with this a couple times now. The state's asking for a gag order because they're concerned about stuff getting out there, and simultaneously they're filing in public filings private information, and I know we dealt with that over the weekend, and then quite frankly, Your Honor, it happened again, and I raised the issue not with the court, but with counsel themselves, because there was a attachment to an exhibit, or an exhibit to a expert witness disclosure. They contained my client's social security number and bank account number, which is, in my opinion, highly problematic. They have since remedied that. However, it was out there for at least a day. And as we know, everything on exchange is being watched by everyone fairly closely, I would assume. I think the timing on this is curious. I filed and have sent a numerous grammar requests to the district attorney's office as well as Summit County Sheriff's Office for, things related to their conduct in this case. I don't know what they know that I don't know. I don't know if they have it. That's a discovery issue we probably need to address, because I'm now being told that they're not turning it over. It's going to take them 3 months. Or there is responsive information, but it's going to take them 3 months to get to me. But that's another thing.
Can we steer in a different direction
Yeah.
for a moment? Among the two major compelling interests that the state describes in its motion, one is preserving the integrity of the process. And I think we'd all acknowledge there are other tools available.
Yeah.
Jury selection in any case that gets substantial publicity will need to be careful, perhaps lengthy, a larger than normal venire, those tools. Here, though, and the state raises it, it's not unreasonable. Is there value in calming the public clamor about this case to protect these 3 kids?
I am all for the protection of the kids, and I am for the protection of the integrity of this process. I don't think it's going to calm it, is my concern. I don't think, they're just, every time that something comes up, they're going to just reprint what's been printed. So I don't necessarily think, and I'm not up here advocating that everybody should be going on national television, just to be clear. Like, that is not where I'm going with this. I hold this process in the highest regard and professionalism. So that's certainly, I don't want the court to think I'm going that way. But I don't think that it's going to solve the problem. I think this is a case that's going to continue to get press. I think there's people that are going to continue to talk that the court has jurisdiction over, or does not have jurisdiction over, mainly from the Richens family, that, have already, there's already so much negative narrative out there with regard to my client that now stopping us from being able to even respond to it, in light of maybe the rules of professional conduct, I just think is unfair, because I just don't think that the press interest in this case is going to go away. If it were a case where I thought it would calm down, then perhaps maybe there would be a value to that. But in this, I don't think it's going to seek to serve what we're trying to do. I think all it's going to do is create a disparity in the narrative that's out there and not allow, Ms. Richens a fair opportunity at some point, perhaps, or whatever, to be able to comment on anything.
All right, I think I understand your position.
Okay.
All right.
Any further questions?
Yeah, let me check in with some other lawyers
And then, just lastly, the First Amendment issue, I don't think, I think that's a high bar to be able to overcome, and, I think there needs to be a legitimate harm. Not that there couldn't be, but, in this case, I think there's a greater harm done with the gag order than otherwise.
I understand.
Thank you.
Thank you. Ms. Chandler, can I put you on the spot for a second?
You can.
You are the appointed attorney for the 3 children in the civil matter. You may not have any thoughts or position on this, but you deserve an opportunity to speak.
I actually do have some concerns based on the fact that there are parties in these cases that are also parties in the juvenile case. And they are also parties that are being looked at as a possible permanent placement for these children. I imagine that is going to be a heated discussion and debate. I would hate to see information being lobbied back and forth in hopes of advancing a better position for the guardianship or the placement of the children through the use of information obtained in these hearings. So that's my concern, is that I do think there is value in calming this and in limiting the amount of information that is in play, because there is an issue of placement, and I would hate to see people fighting that battle in the public arena, especially where the kids could possibly have access to or see what other family members are alleging against each other.
All right. It's a good summary of that concern. As a practical matter, how would you recommend that the court address it, given the limitations on prior restraints of speech under the First Amendment?
I think we can limit it to parties in these matters and counsel. I have less of a concern with police officers, obviously. I mean, I have a narrow focus. It's just as to the children. I don't want a fight to go public on where these kids should go.
All right, I appreciate that. Anything further?
No.
All right. Mr. Tracy?
Yes, Your Honor. Well, we certainly want to cooperate, but initially, our initial feeling was the gag order should be limited to the criminal action. It's difficult, and I'm speaking specifically with regard to the estate case. It's difficult to predict what we will need to talk about in the estate case with creditors of the estate, for example. And we don't want to always be wondering if we're violating a gag order in the criminal action by the way we're handling the estate matters. And let me give you an example. Let's suppose we have a creditor with a claim based on a loan. We disallow, the personal representative disallows the claim based on her belief that it was obtained using a fraudulent power of attorney. That same power of attorney may or may not be at issue in the criminal case, but we're going to need to be able to discuss that document in statements that would probably be defined as an extra judicial statement. And we don't want to be restricted on what we can say with regard to that key document as our client administers the estate case. I'm not talking about it with the press, but frankly, the gag order is a lot more restrictive than Rule 3.6. Rule 3.6 at least it applies to extrajudicial statements, but it cabins it by saying it'll have substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. I don't think that we necessarily even have that clarification in the gag order. Again, we would like to work with the parties to come up with something that protects everybody's rights, but an estate case isn't something that can just be stayed in total. There's going to be creditors. There's deadlines for creditors to make claims. There's deadlines for the personal representative to allow or disallow claims. Then there's deadlines for creditors to file petitions to allow those claims. And there's going to have to be discussions that, between counsel and maybe witnesses regarding, that process. So overall, our initial feeling is the gag order should not be applied to any case other than the criminal matter. But we're certainly willing to work with the parties to come up with something that's reasonable.
All right. Mr. Nate, anything to add?
Yes, just briefly, Your Honor, if that's okay.
Sure.
Your Honor, I think I'd just like to reiterate, the arguments that Ms. Lazaro made and Mr. Tracy as well. I think as an initial matter, having this extend to both the estate case and the trust case is probably beyond the scope of what is necessary. Those two actions have been going on for well over a year at this point, and as you know, there are motions to stay, and so I don't know, what effect imposing that in those cases are going to have. And again, I just think it's important to reiterate the fact that if the court is considering actually entering this order, that the parties be given an expedited process, but we have an opportunity to be heard in all respects.
All right, thank you.
That's it. Thank you, Your Honor, appreciate it.
Mr. Hinton, anything?
No,
Ms. Gusell, the state will have the last word.
Your Honor, just a couple of things. Just with respect to what Mr. Tracy said about, and this is only, our request is only to apply to the media. This is not conversations between witnesses and attorneys or between two witnesses. We are only talking about a gag order with respect to conversations with the media. So.
Isn't that worse?
Well, but that's where the problem is, right? That's where the problem with the integrity of the process. It's not, we want to continue the process with the other cases, and with this case, it's where the problem is with all of the craziness with the media and the craziness with them trying to contact witnesses and contact parties, and that's where the integrity is going to break down, not with lawyers talking to each other or lawyers talking with their other witnesses. And with respect to calming this down, I think this could solve the problem of calming it down, because if they're not out there digging up or trying to dig up witnesses or parties or law enforcement, then all they're going to have, and I understand Ms. Lazzaro's point that maybe they want to respond, but the problem, but if what they have is what they have right now, they're not going to. It is going to calm it down if they're out there trying to find a witness or find somebody who's going to give information. That's just going to harm the process. That is our reason for this, is to protect the integrity of the process.
Thank you, Ms. Gusell. All right. The issue before the court is the state of Utah's motion for a gag order. While the court has concerns that the level of publicity in this case has not been in the interest of justice and is not inuring to the benefit of a fair and impartial trial, the fact remains that under the First Amendment of the United States Constitution, there is a constitutionally protected need for free and unfettered expression. That protection can be overcome if the state's interests are sufficiently compelling, and here, preserving the integrity of the process, and also protecting minor children from a public clamor that is potentially biased and or inaccurate regarding one of their parents, constitute compelling interests. But the mere existence of the compelling interests is not sufficient to overcome the presumption in favor of free and unfettered expression. Rather, the court has to look to and compare those compelling interests to other tools that are available to preserve the integrity of the process, ensure a fair and impartial trial, and protect the minor children. With respect to the minor children, the juvenile court is best equipped and has the legal authority to make whatever orders are necessary to protect those 3 kids from whatever comes out of these 3 cases. The court determines that the juvenile court is actively engaged in that process and should be trusted to effectively manage it. With respect to preserving the integrity of the process, that is, ensuring that Ms. Richens, who is presumed innocent, receives a fair and impartial trial and a timely one. There are other tools available, such as in-depth voir dire during lengthy jury selection, a potential change of venue if things get out of hand. Moreover, counsel of record and their teams and their expert witnesses and their investigators are bound by Rules 3.6 of the Rules of Professional Conduct and 3.8 as it applies to prosecutors to not make extrajudicial statements that are likely to prejudice the process. Given those other tools available to serve the compelling interest of ensuring the integrity of the process, the court rules that the state has not made a sufficient showing that a gag order serving as a prior restraint of speech by the parties, witnesses, or others would pass constitutional muster. For these reasons, the motion for gag order is granted in part and denied in part as follows. It is granted to the extent it seeks an order stating that lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide by Rule 3.6 of the Utah Rules of Professional Conduct. Moreover, it is granted to the extent that it requests an order that lawyers who have participated, who are now participating, and who will yet participate in the investigation or litigation of this criminal case shall not intentionally, knowingly, or recklessly permit any witness, investigator, consultant, staff member, or other member of their teams to make any extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. And the court is ordering the lawyers participating in the investigation and litigation of this case to inform their witnesses, investigators, consultants, staff members, and other members of their teams about the terms of the court's order in this regard. The court rules that this order applies to all 3 cases for the following reason. The amended information in the criminal case describes several financial transactions and circumstances that are also implicated in the estate case and the civil case. And that financial story, whether it's being alleged to describe motive or some other relevant issue in the criminal case, is intertwined in the other 2 cases. And therefore, there is good cause to apply this limitation, this protection order, across all 3 cases. Having said that, the motion for gag order is denied in all other respects, without prejudice. If circumstances change in some unexpected way, the balance of the compelling interest expressed by the state versus the protections offered by the First Amendment may change. Ms. Cassell, do you need any clarification of the court's order?
I don't think so, Your Honor.
Ms. Lazara?
No, Your Honor, thank you.
Mr. Nate?
No, Your Honor, thank you.
Ms. Chen?
No, Your Honor.
Mr. Tracy?
No, Your Honor.
All right. Counsel, everyone else online, I thank you very much for your patience and decorum. Ms. Richens, I wish you the very best. I'll see you on June 12th. Please take care. Court's in recess. Thank you.